Good evening. Welcome to Santa Rosa Insider Weathering the Storm. Now, without further ado, I'd like to introduce our guest this evening as the principal of the law firm that handled the Mierzwa case. Would you please, in a nutshell, help the viewers out there who have never heard of this case? And unfortunately, there are probably very many of them who have never heard of it when, in fact, they may need to know about it. If you could tell them about the case.
The Mierzwa case is a case that came to me in late 1999. It's a gentleman whose home had been destroyed in Hurricane Irene. It was in one of the islands in Fort Lauderdale towards the ocean off of Las Olas Boulevard. The home had a value in its policy of $281,000. And the wind insurer determined that they were responsible for only 57% of the damage. And they tended to check for about $73,000 plus some extra money for some cleanup. And essentially what the case does, and the flood insurer, he had flood insurance pursuant to the national program, and they tended their 53% of the damage, which gave them approximately $120,000 for a home that was worth almost $300,000. And the home had been totally destroyed, totally destroyed. Actually, it was constructively destroyed in as much as, I mean, you couldn't use it as a home anymore, but because if you wanted to, you had to bring it up to code. Because Fort Lauderdale, like every municipality in the state of Florida, to my understanding, has the 50% rule, which is if the house, if the house is sufficiently damaged that it will take 50% or more of its pre-casualty value to bring it up to present code, you can't rebuild the house. You need to basically build a new house up to code. In Fort Lauderdale, the expensive issue there is pilings, because this house was built before they had elevation requirements. The flood program dates from '68. So pre-'68, you could build below what's now called the floodplain. You can't do that anymore. That involves driving pilings. Average person can't do that. What the 4th DCA, the 4th District Court of Appeal, held in Mierzwa was, they ruled for Mr. Mierzwa. We won. And they ruled that that statute, the valued policy statute, says if your house is insured for a covered peril and it is totally destroyed, whether constructively or actually destroyed, the insurance company must pay you the face value of the policy, which is determined by the insurance company, not a pro rata share of it. And I don't know how much you want to discuss, the purpose of the policy and the history of it. I could be happy to get into that with you if you're interested in it. But that's essentially the holding of the case. I should caution your viewers that each policy and each situation is different. In other words, Mr. Mierzwa had an insurance policy with a company. Most companies offer more than one policy. So a different policy, the result might have been different. Different facts, result might have been different. Each case is an entity unto itself. But that's basically what the Mierzwa case holds.
The majority of his damage, 57% you indicated, Stuart, was in fact caused by wind. What if it's the reverse? What if it's 57%, or let's give a worst case scenario, what if it's 90% flood and only 10% wind? Do you maintain in those instances that under the value policy law, the wind carrier would need to pay the full face value of the policy?
Interesting question. Let me say this first. The law is, to quote Justice Oliver Wendell Holmes, the law is whatever the judge tells you it is. The law isn't static. It changes. And in the Mierzwa case, the court left that open. They really actually acknowledged that. They said this is a case where the majority of the damage was done by wind, and wind is a covered peril. The attorneys on the other side of the case kept saying, well, what if the wind was only 1% of the damage and the rest of it was flood, which was not a covered peril under the policy? And they said, well, those aren't the facts. And they actually left that open for another court. If that case does arise, and I'm sure that case is out here, a court may address it differently. One of the things that makes our job interesting is that you can never be sure what the result will be, because the law, as I said, is not static. It changes. That 1% case, I'd love to argue it, but that would be an avenue. If a court wanted to distinguish the Mierzwa case, given those facts, a result could be different. I don't think it should be different. There is a reason, and a good one, for the valued policy law, and I'll tell you what it is. Over 100 years ago, insurance companies regularly would say to people, we're going to insure your home for its value. The value of the home is $6,000. That was a nice home back then, by the way. And they would know that the home could be rebuilt for $4,000. And the company would collect premiums based on the valuation they gave. When there was a casualty loss, they'd say, oh, well, we can rebuild it for $4,000. So they would be collecting premiums on an inflated value which they knew they would never be called upon to pay. As Scott said, in 1874 in Wisconsin, the legislature said, wait a minute, we're going to stop this. If you want to collect a premium based on that amount, that's fine. We'll let you do it. But if the house is destroyed, you're going to pay that amount. So the argument I would make, and I made this argument in Mierzwa, is that once you take that element out, the insurance companies then can go back to what they used to do 150 years ago. So the valued policy law was enacted. There's about, I'd say half the states in the Union have them as of today. It serves a very, very good purpose. It protects consumers.
One of the viewers sent me in a question in advance of your coming on the program, and she indicated that her insurance company that handles both her wind and her flood policy just recently informed her that the valued policy law, this is a quote from the insurance company, is not applicable because the covered peril, wind, did not cause the harm to be a total loss, total being underlined. Can you comment on that, please?
Yes, I can. If there was wind damage, then the valued policy law applies if she had a wind policy, because the policy, it can be boiled down simply to this. If you had coverage for damage by wind, and you had any damage by wind, any at all.
A shingle missing.
Even if there were other elements contributing to the damage that weren't covered, such as flood, the valued policy law says that the homeowner is entitled to collect from the wind carrier the total face value of the policy. Now, if a shingle blew off, that wouldn't be the type of damage that would be, because you mentioned that, and I wouldn't go that far. I would have to say it would have to contribute to the total destruction of the home, either actual or constructively.
So when you say constructively, here a lot of people are trying to deal with the 50% rule, and they're getting a letter from the county that says your cost to rebuild is going to exceed or 50% of the pre-disaster condition of the home. That is not necessarily in the insurance industry's determination a total loss. But from the county perspective, they're saying, you've got to tear it down. You've got to rebuild.
That's right.
That's when you use the term a constructive loss. It still would constitute a total loss. Is that correct?
That's correct. Under the value policy law, and this was decided prior to the Mierzwa case, it's maybe 30 or 40 years old, a constructive total loss qualifies as a total loss for the valued policy law. And the constructive total loss, the concept, really comes from the federal law that was passed in 1968 that set up both FEMA and the federal flood program. And it required, if a community wanted to be able to have federal flood insurance available, the community had to require that in the event a home was subject to the 50% rule, it was sufficiently damaged so that rebuilding would require funds equal to or more than 50% of the pre-casualty value. The home had to be brought up to code. The reason for that is evident because the flood program wanted to know that all the homes that were repaired would be above the 100-year floodplain. That's one of the things you have to do. It can be terribly expensive, bring a home up to code.
Okay.
Driving pilings.
We have a call. Go ahead, caller. Are you there?
Yes. I actually have two questions. The first is, being in a very conservative part of the state, do you think we have a more inherent risk in a jury maybe not siding with the Mierzwa case? And secondly, my house on pilings. And I'm curious what the people you have in the studio would say about whether or not I would be able to get the law and ordinance coverage, the extra coverage on my policy, the extra 25%.
May I take a chance at that first part of the question?
Go ahead.
The Mierzwa case is an issue of law. It is not something that a jury would ever decide. The Mierzwa case is the District Court of Appeal for the 4th District addressing the valued policy law in conjunction with this policy that Mr. Mierzwa had and saying what the law is. That's a legal determination. Such determinations are made by judges. Juries decide questions of fact.
All right, let me make sure that the viewers understand that, because I've talked to a lot of people that say, oh my gosh, if I can get this case in front of a jury of my peers, other people that have lost their home, it's a slam dunk. But Stuart, what you're saying is this is a case that very likely would never make it to a jury. Is that right?
Well, if you can establish, as a matter of fact, undisputed fact, that's how Mierzwa was decided. The district court decided he had insurance, his home was destroyed by a covered peril to the extent of 57% of the damage, and they said under the valued policy law, even though he collected from the flood carrier 43% of the damage, that the carrier had to pay, the wind carrier had to pay the total value of the home.
Could it be deemed bad faith for one of the insurance companies to send an insured a letter like this that says, we're not recognizing the Mierzwa case, or you don't have valued policy coverage in your policy? Is that bad faith? Can you tell the viewers what's meant by bad faith, and if it is bad faith, what that might mean for them?
If it's a policy of insurance written in the state of Florida that covers a building or a structure for casualties, fire, storm, hail, hurricane, it's subject to the valued policy law. The only exception would be policies of insurance which are written pursuant to the National Flood Program. They are under federal law, which is different. But with that one exception, for flood policies written under that federal statute, valued policy law applies. In my opinion, if an insurance carrier of a state casualty policy tells a homeowner that the valued policy law does not apply, and it's a situation where a covered peril has contributed to the total destruction of a home, whether actual or constructively, that's bad faith, in my opinion. And I would pursue that. I would pursue my rights under my policy as well as my bad faith claim.
And that would have to be a separate claim someone would bring.
Bad faith claim is a separate claim. You must prevail on the underlying claim to bring it, and it's the type of thing that you'd need a lawyer for it. You have to file a demand letter with the insurance company. You need to file a form, a rather detailed form, with the Office of Financial Services in Tallahassee. But if you were to be correct, if you prevailed on the underlying claim and you could establish that the insurance company, essentially, the test is, did they deal with you in bad faith? You could then get more damages, including punitive damages. It's a separate tort, is the legal word for it. It's a civil wrong done, not a breach of contract, but a civil wrong done, for which an insurance company can be required to pay damages for harming you.
If someone hires an attorney to handle a total loss case like this, how are the attorney's fees handled?
Well, we talked about that over the break, so one of you go ahead.
Okay, just briefly, the Florida Supreme Court has set forth guidelines for contingency fees, and we abide by those guidelines. In fact, we take that portion of the Florida Bar Rule that sets forth the contingency amounts that are allowed, and we just basically put them into our contract. And for example, if the case goes to trial, the fee is 40%. If the case is settled easily without an insurance company filing an answer, which has never happened to me, but the rules do provide for a lesser amount of money in those circumstances. So depending on the amount of labor the attorney puts in, the fee escalates accordingly.
What would you say to the individual insured who receives a check from their insurance company, but they're not quite sure whether or not they're ready to accept that that check? Should they go ahead and cash it? Should they note something on it? What would your advice to them be?
Well, first of all, every check you receive from an insurance company has to tell you exactly what coverage it's for. If it doesn't, that's described in the statute on bad faith as bad faith. They need to tell you what they're giving you and why they're giving it to you.
Okay.
But if anybody out there gets a check and they're not sure if they want to accept it, they should contact an attorney. That's not a decision that I would recommend that anyone try to navigate on their own. I think that that requires legal advice from someone who is prepared to address that situation.
Let me ask you this. What about the individual who was told by their insurance carrier that they didn't need flood insurance coverage? Now, this is a little bit different situation than the Mierzwa situation, but we have plenty of folks here that were advised by their insurance agent that they did not need to have an entirely different situation, that they didn't need to have flood insurance coverage.
Let me address that because I've litigated somewhat similar situations. If you can prove it, that's usually not easy to do, but if you can prove it, you have a claim against that individual under their O&E policy. They're usually insured for it under their error and omission policy. It's a type of negligence that an agent would be liable for.
When we talk about the valued policy law, does that cover contents?
No, it covers buildings, structures, that type of thing. It doesn't
Okay.
address contents. Contents are different.
Okay, so even if her home was deemed a total loss in part by wind and part by flood, the only portion of the contents that she would get would be that which they could actually prove resulted from the wind damage. Is that right? I mean, how do you determine that? And here she's in a situation now where she's essentially getting nothing from her wind carrier for all of her contents.
I'd need to read the policy before I could answer that question, because
Okay.
the policy could have coverage, it could not provide coverage. It depends on what's in the policy. Somebody's commented on the conservative nature of juries here, and would a homeowner be able to prevail against an insurance company? And I just have this feeling flying in today from Fort Lauderdale. It reminded me of the devastation in Dade County after Hurricane Andrew. And as Scott said, we're all Floridians. If I were an insurance company, I'd be afraid to go in front of a jury here. I really would. I don't think anybody should think that this is a conservative part of the state and you should be afraid of a juror. I think that most people who live here are going to, if all things are equal, they're going to feel really sorry for that homeowner.
Can you shed some light on why it is that the insurance company did not appeal this case? Because there are rumors floating around. Some of the insurance companies were even saying that this isn't well-settled law yet, that this may still be appealed. In fact, Stuart, you advised me that that is not true, that this case is in fact done. Mr. Mierzwa has received his payment. He's gone on to live a very happy life, I hope.
That's correct. I believe Mr. Mierzwa is living a very happy life. He's happy, and the case is not being appealed. It went to the 4th District Court of Appeal. A decision was rendered. They filed a petition in June to take it to the Supreme Court, and then about 3 weeks later they withdrew it. They withdrew the petition to the Florida Supreme Court. The case is over.
Okay, that's all the time that we have for this evening. Thank you very much for joining us for Santa Rosa Insider Weathering the Storm. I hope you weather the storm this next week and can join us next week Wednesday at 6 p.m. on Channel 27 Gulf Coast Network.